Michael Popok, Legal AF After Dark. A lot of reporting that it was a terrible setback for Jack Smith, and a bonus to Donald Trump that the U.S. Supreme Court has decided to turn down Jack Smith's request for expedited briefing and a direct appeal related to whether Donald Trump has presidential immunity from being criminally prosecuted in the District of Columbia or not. Not so on Legal AF. We think it's not that big of a deal. And in fact, having the District of Columbia courts and the 3-judge panel there go first and make a decision in early January before it goes to the Supreme Court is probably a very good thing for justice. We break it down on the most recent episode of Legal AF Podcast. Take a listen.
Look, what special counsel Jack Smith filed with the Supreme Court, Jack Smith admittedly said it was extraordinary relief. And Jack Smith filed what he did before the Supreme Court, before he got word back from the D.C. Circuit Court of Appeals that the D.C. Circuit Court of Appeals was expediting everything, where you would have written briefs that would be due by January 2nd in the appeal on the issue of absolute presidential immunity, and oral argument by January 9th before the D.C. Circuit Court of Appeals. Now, in the normal appeal process, as I said on the hot take that I did before, you don't take the elevator to the penthouse. You don't go from the district court to the Supreme Court. You go through steps. You go from the district court, the Circuit Court of Appeals, and then the Supreme Court can accept certiorari on a special writ petition for the Supreme Court where issues that are presented are so unique, or there's a circuit split throughout the country, or whatever the reason is that the Supreme Court decides to hear the case. Now, I think the key reason why the Supreme Court ultimately said, and why there was no notable dissents, why they denied special counsel Jack Smith's petition for certiorari here, this direct appeal, before the D.C. Circuit Court of Appeals even makes their ruling on the issue of absolute presidential immunity, is because that D.C. Circuit Court of Appeals set such an expedited schedule that the Supreme Court can kind of sit back, see what the D.C. Circuit Court of Appeals rules by mid-January, and in terms of how long this would actually delay things, I mean, you're talking about a 45 to 60, maybe a 75 to 80 day, 90-day delay. If the Supreme Court hears oral argument after the D.C. Circuit Court of Appeals rules. And I think that's why you don't really see any dissent. And that's why at a later stage, if the D.C. Circuit Court of Appeals rules that it's going to stay all proceedings while Donald Trump is seeking a certiorari to the Supreme Court, after I think we're all very confident the D.C. Circuit's going to say Trump does not have absolute presidential immunity. And then in a few weeks, when this goes back to the Supreme Court, and if the Supreme Court then refuses to accept certiorari while there is a stay, and they don't hear it in this term, if the D.C. Circuit has a stay, that would be devastating news. That would be bad news. And Michael Popok and I would then say this case cannot happen in 2024. Now, if the Supreme Court in a few weeks after the D.C. Circuit Court rules, it grants certiorari, right away or very quickly, whether I think Jack Smith will probably move very quickly again, even if Donald Trump would seek certiorari as well, because Donald Trump's going to be the losing party. But I think Donald Trump tries to wait and delay. So Jack Smith, I think, will file it right away with the Supreme Court and basically call that out. Hey, look, now the D.C. Circuit Court of Appeals ruled we're mid-January. If the Supreme Court then hears certiorari, sets briefing, by February, oral argument by mid-February, late February, we'll have a better understanding of when this trial date is going to take place in the Washington, D.C. federal criminal case. But it will take place in 2024 then. So that's why this specific move did not make me really even blink. And for those who watch Legal AF, I hope that we've prepared you for that ruling. We've talked about that being the likely scenario. And here's the thing, Popok. Judge Tanya Chutkan has said she doesn't care when this, she doesn't care about the election cycle. She's going to try the case when the case is ready. That's the federal judge at the district court level who denied Donald Trump's motion to dismiss on absolute immunity grounds, absolute presidential immunity grounds. So the question then just becomes is where is this case, where does it get sequenced amongst all of the other cases? But that because the DC Circuit expedited this so quickly, and we're going to hear from the DC Circuit, we're going to know where they're leaning on this issue, I think, on January 9th. On oral argument, I'm sure we're going to do a hot take that basically says, because you can predict these things, that, wow, this circuit it was a hot circuit. It was scathing, the questions they were asking Trump's lawyers, and Trump's going to lose. Then it's just how quickly thereafter is there an order. And then Jack Smith goes back to the Supreme Court. That's the time for me where if the Supreme Court makes a bad ruling, I could then say to everybody, yes, this Supreme Court has zero legitimacy on this issue, in addition to all the others where they've unfortunately lost most of their legitimacy. So that's kind of my take on it, Popok. What do you think?
I'll go one step further. I'm not troubled at all by the U.S. Supreme Court denying the writ of cert for direct appeal. And I am actually take a lot of confidence from it first coming up from a panel of 3 judges in the D.C. Court of Appeals, Judge Pan, Judge Childs, and was it Williamson, Harrison? It's 2 Biden appointees,
Henderson, yeah.
Thanks, Ben, one G.W. Bush appointee, and given Judge Pan, Judge Pan and Judge Childs' prior rulings, especially Judge Pan, on things related to Jan 6th, I would be shocked if they ultimately rule, given the precedent that's already been set in the D.C. Court of Appeals about immunity just recently, and the analysis that I think is rock solid in Judge Chutkan, the trial judge's own decision-making. I'd be shocked if that a panel of the D.C. Court of Appeals rules in favor of Donald Trump and finds that there is some sort of absolute presidential immunity that bars and bans any prosecution of a now former president for committing crimes while he was president. It's a terrible precedent to be set. It's not one that's consistent with our constitutional principles, nor our system of government or the role of the president in our system of government. And I'd be shocked if they did that. The reason I believe that, and chef's kiss and tip of the hat to Jack Smith, the reason I believe he filed both those pieces of paper at the same time. One, the writ of cert to the U.S. Supreme Court, asking them to take a direct appeal on an expedited basis, and at the same time, almost simultaneously, saying the exact same thing to the lower level appellate court I believe, was to put pressure on the D.C. Court of Appeals to rule quickly, set a briefing schedule quickly, and rule quickly under the threat or the shadow that if they didn't, the U.S. Supreme Court would step in and take the case from them. And they did exactly that. If that was his goal, to get one of these courts to wake up and set an oral argument for early January, he got exactly what he wanted. And if I were him, I'd be happy right now, not sad as the reporting has been in the most reporting with the headline, Trump wins, Supreme Court throws bone. That's not how I saw it at all. I know from your analysis just there that you as my co-anchor doesn't feel that way either. I felt if I'm Jack Smith, I'd be like, great, I'm going to get a well-developed record on briefing before a favorable panel of the D.C. Court of Appeals, and then I'm going to take that up on an expedited basis, I hope, to the U.S. Supreme Court. I will also go out on a limb, and if I'm wrong, I'm wrong. As we like to joke, we're the almost never wrong podcast, that the U.S. Supreme Court is not going to sit on their hands when it's their turn to look at the case in mid-January. The oral argument is the 8th. It's either the 8th or the 9th of January for the D.C. Court of Appeals. The 9th, thank you. They're going to rule by the 11th or the 12th. It's not going to go weeks. We've seen these different panels of the D.C. Court of Appeals throughout the last 2 years rule very quickly when history propels them to do that, and they will here. I'd be shocked if they didn't. So by mid-January, 15th or so, there's going to be an attempt by the loser to take the case on expedited basis now to the proper appellate court, the last stop on the train, last stop on the elevator, in your analogy, the U.S. Supreme Court. Now you got John Roberts having to get 5 votes to grant the writ of cert for the appeal, set emergency briefing, and make a decision. I know you're you're of the opinion, I've heard it on our last 2 podcasts, and I know why. I know the reason you're saying it, and it's not wrong, that it could take still 30, 45, or 60 days if it ends up with the Supremes. It doesn't have to take that long. I mean, as I pointed out last podcast, it took 72 hours for the United States Supreme Court to decide that George W. Bush was the president of the United States, coming off of a decision that they reversed by the Florida Supreme Court in Bush versus Gore in 2000. Literally 3 days. They set, and this is one topic for today and on Hot Takes that I'm doing along with you this weekend, Ben. One topic is the United States Supreme Court moves at its own internal clock and its own pace. There is no rule book for it. Some people might think, isn't there like a book they got to look up and tells them with a timetable when they have to take things? The answer to that is no. They make their own decision about when they're going to brief, what they're going to brief, if they're going to delay it until normal track appellate briefing, which means you won't find out until March, April, May, or June, or they're going to do it on something faster. Are they going to do it in 72 hours, 72 days, or 72 months? It's all up to the United States Supreme Court and ultimately the chief judge running the caucuses behind the scenes with the other judges. Can they count to 5 to get 5 votes to take the case on an emergency basis? Yes or no? Obviously, at this moment, they didn't have those votes. 6-3 supermajority in favor of MAGA on the Supreme Court, but with a slightly more moderate John Roberts trying to hold this thing together and hold the center together on this particular case. So I think it could go, and I think this is what, if Jack Smith runs the table here, this is the way it will go. He got his emergency appeal quickly expedited by the D.C. Court of Appeals, who felt the pressure of, if they didn't move quickly, the Supremes might step in, and they want to do their job. Trust me, they don't want to give this up. And so he got that win. Jack Smith then gets a great ruling in about 10 days or so, 2 weeks or so from that panel. And probably written, if I had a guess, by Judge Pan, but we'll see. In the majority, maybe it's 2-1, but that's enough. And then a very quick expedited appeal on writ of cert to the Supremes, who know all about the case. They just saw it 2 days ago, and they go, yes, now it's time and right for us to take the case. They then do emergency expedited briefing. We get an oral argument at the end of January, and now we get a ruling perhaps as early on an emergency basis in February. I don't think the D.C. Court of Appeals is going to stay a darn thing if they rule one way or the other. And if they rule for Jack Smith, I don't think they're going to stay the thing in terms of the trial setting. They'll let Donald Trump go to the duty judge, who is John Roberts, to decide whether there's going to be a stay pending the appeal. He'll probably grant an administrative stay of the whole proceeding for Judge Chutkan while they take the issue up on briefing. And then we could have an entire ruling and a final declaration by the U.S. Supreme Court by the end of January, maybe beginning of February, on the issues. In the meantime, as you've talked about on Hot Takes, and we've done it midweek, or you did it midweek, Chutkan's just doing what she can administratively to keep the wheels on this train for the March trial. Jury selection and jury things that she can do that aren't substantive per se to keep the case on track. And she's going to continue to try to do that. Could the case slip from March? Sure. Could it slip into an April, May, or June slot? Sure. Is that enough time to have the case fully tried by a jury in the District of Columbia on the 4, and there's an asterisk next to the 4 crimes that have been charged, 2 of which we'll talk about later in the podcast about whether they are going to survive Supreme Court review, the obstruction of an official proceeding charges against Donald Trump, but he's got 2 other pretty heavy charges against him there that will go to trial. Could it all be tried well before the voters vote in November on the ballot? Absolutely, which is what we're trying to accomplish. But that dystopian timetable, Ben, is also possible that you outlined, which is there's 45 days, there's 50 days, there's stays, and the Supreme Court doesn't move at all, giving a win to Donald Trump and letting the voters make the decision, not the court system. And there's always that battle between the political questions and voters. But we've seen the U.S. Supreme Court, as I said, ending my analysis of where I started. In Bush versus Gore, they had no problem intervening and choosing our president. Same thing here. They're going to have to decide once and for all on a new body of law whether a former president now, who was president then, that it's alleged in an indictment to have committed crimes, and one last wrinkle, who was tried in the House and impeached by the House, in this case the Democrats, but not convicted by the Senate on similar claims, whether his indictment stands thumb up or thumb down. We're going to get that ruling in the first quarter of 2024, period, and that's going to make new law for our republic forever. Well, there you have it. If you like lawyers who know what they're talking about at the intersection of law, politics, and justice, you're going to love Legal AF. It's one place and one place only on the MeidasTouch Network. You knew that. You're watching me here. I'm Michael Popok, and on Wednesdays and Saturdays, I co-anchor the show. On Wednesdays with Karen Friedman-Icnifilo. On Saturdays with my co-founder and really great friend, Karen's a great friend too, of course, Ben Meiselas. And then you can pick us up on audio podcast platforms of your choice. If you know what I'm talking about and all about Legal AF, welcome back. Appreciate you. If you have no idea who I am and what I'm talking about, I'm Michael Popok. That was Legal AF, and we'd love you to join us for the next go around. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.